Aside from the OSG's submissions in the present cases, we take judicial notice of the Duterte administration's 2017 year-end report, where deaths in cases related to illegal drugs and the internal cleansing conducted within the Philippine National Police are touted as accomplishments. And Your Honor, the next sentence is emphasized in the original resolution. The government's inclusion of these deaths among its other accomplishments may lead to the inference that these are state-sponsored killings. In the section Fighting Illegal Drugs and subsection Real Numbers, we find the following figures. And Your Honor, I will just quote the one that was in emphasis in the resolution. 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. As well as 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. 6. The defense referenced, again, the same Philippine Supreme Court resolution. But that same resolution held that nothing else to substantiate the OSG's claim of legitimate police operations. And I quote that specific portion in the Philippine Supreme Court's Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at page 47. The Supreme Court held that, and I quote, apart from these numbers and their bare allegations, there is nothing else to substantiate the OSG's claim of legitimate police operations. The lack of any submission of the required information and documents leads this court to believe that there is no basis to the OSG's claim. It is Hornbook doctrine that bare allegations unsubstantiated by evidence are not equivalent to proof, i.e., mere allegations are not evidence. End of quote. 7th, Your Honor. Again, in reference to the same Supreme Court resolution referenced by the defense, the Supreme Court also held there that the PNP cannot claim presumption of regularity on deaths occurring during police operations. Your Honor, I will quote that specific portion of the Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at pages 47 to 48. The Supreme Court held, and I quote, the PNP cannot claim the presumption of regularity in official functions because deaths are not supposed to occur during any of their operations. The presumption of regularity in the performance of official duty must be seen in the context of an existing rule of law or statute authorizing the performance of an act or duty or prescribing a procedure in the performance thereof. The presumption also cannot prevail over positive averments concerning violation of the constitutional rights of the accused. And Your Honor, in the next paragraph, all of it is being emphasized in the original. And I quote the emphasized portions. The Duterte administration's 2017 year-end report states that there were 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, and 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. This is a total of 20,322 deaths during the Duterte administration's anti-drug war from July 1, 2016 to November 2017, or an average of 39.46 deaths every day. This court wants to know why so many deaths happened, as expressly reported under the section Fighting Illegal Drugs of the Duterte administration's 2017 year-end report. Next, Your Honor. The Philippine Constitution provides for the right of life in Article 3. Therefore, because of that right to life, there is actually no presumption of regularity if a person is killed during a police operation. And actually, the presumption is reversed. It's actually the onus probandi on the police to prove that his or her actions were within the lawful requisites of self-defense. In fact, Rule 15.4 of the 2013 revised PNP operational procedures mandates the proprio motu investigations if death occurs during a police operation. However, Your Honors, despite the at least 3,967 deaths under anti-drug operations, there was no proprio motu investigations for all of these deaths. 8, Your Honor. The defense yesterday referred to the Philippine National Police Operational Procedural Manual issued in 2021. But the same was irrelevant and a non sequitur with respect to how the PNP construed and applied the word neutralize under CMC 16-2016 from July 1, 2016 until March 16, 2019, which is within the temporal jurisdiction of the court. The defense recognizes that the same Philippine National Police Operation Procedural Manual was published in 2021, specifically in September 2021. And it was already after the temporal jurisdiction of this court. Hence, it's irrelevant with respect to this case. 9th, the defense asserted that purportedly the Duterte's administration is, and I quote, intolerant for rotten apple police officers, end of quote. That's in the transcript of yesterday at page 32, line 20 to 21. This is not true, Your Honors. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for the government-recognized deaths of at least 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. In fact, the undisputed fact in this case is that the Philippines only investigated
Excuse me, counsel. You have 5 minutes left.
At most 302 cases. And I refer to the February 27, January 26, 2023 decision of this chamber on the authorization pursuant to Article 18, Paragraph 2 of the statute to resume the investigation. The court here, the chamber has held, the chamber observes that at the time of the prosecution's request, the DOJ panel had referred to the NBI for investigation in case build-up 302 cases consisting of 52 PNP IAS cases, the non-Laban cases, and 250 NPS cases. And in paragraph 39, from the information before the chamber, it therefore appears that the DOJ panel review does not amount to relevant investigations within the meaning of Article 17 and 18 of the statute. Moreover, the number of cases reviewed by the DOJ panel, namely 302, is very low when compared with the estimated number of killings that allegedly occurred in the context of war on drugs operations. Res ipsa loquitur. Mr. Duterte's administration has not criminally prosecuted the the police officers responsible for these deaths. Last, Your Honor. The defense erred when it conflated Ms. Paulina Macida's statement that Rodrigo Duterte failed to prevent or punish with the theory that the prosecution has not charged command responsibility under Article 28. Ms. Macida's comment on the fact that Mr. Duterte did not take steps to investigate and prosecute was pronounced in the context of her submissions on the fact that encouragement of killings through public statements by Mr. Duterte sent a clear message that those responsible need not fear accountability and can act with impunity. Said comment cannot be extrapolated from that context, as the defense did yesterday. We do not suggest that Mr. Duterte should be liable under Article 28 of the statute. We maintain that there is ample evidence for confirming the mode of liability under Article 25(3)(a) as pleaded by the prosecution. Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed, and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor. Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice. Because in the end, Your Honors, the victims, they're also created in the image of God, and they also believe that the God of the universe is the God of justice. Madam President, Your Honors, thank you for your kind attention. This ends the presentation, the closing statement of the Common Legal Representative for Victims. May it please the Chamber.
Judge Motok. Thank you very much, Mr. Andres. We will now take our break and resume with the final submissions of the defense at 1400 hours. The hearing is suspended.